And we are live. Welcome to the Guns for Everyone podcast. Today's going to be more professional, I think, when we have an attorney as legendary as the one we've got today. We've got to mind our P's and Q's just a little bit, just a tad bit. My name is Edgar. The guy up top is
Isaac. Sorry.
Isaac
I never know if you're going to say it
Yeah.
or throw it to me or what. Yeah.
No clue. We're just winging that shit. Today we have as a guest Brian, attorney DeBauche. I always like second guess myself when I say that. I've known you long enough. I think I should already know it. So welcome. I appreciate you being here.
Thanks. I appreciate being here.
Yeah, thanks for making time to be here.
Sure.
I don't know what Isaac has in mind in terms of the structure or what he wants to talk about, but I do have one thing that I wanted to bring up.
Hit it.
This is an old case of yours.
Mm-hmm.
We've talked about him before, Sean. It came up in a class,
Mm-hmm.
and I think he said he gave you permission to talk to us about it, but I don't know. I don't want you to go to your notes or anything like that. All I want to know is, and confirm or deny, he was charged with the mag ban of possessing a 17-round magazine.
True.
You fought it for him.
I did.
And got his case dismissed.
I did.
Nice.
Yeah.
So there was issues in the class with people who overthink it. I think that's the biggest thing with reading simple laws is often people like overthink it or don't understand the nuances of how the laws actually work. Like the laws can sometimes say one thing and it's mostly true, but until it gets tried in court, nobody really knows how it's actually going to go, right? The unfortunate thing, we don't have the benefit of district appeals. We don't have, especially for that particular law, we don't have anything that's been appealed, so we don't really have much annotations. Yours was kind of a straightforward. They accused him of something. You filed a motion to dismiss before it even went to trial.
Oh yeah, well ahead of trial.
Yeah,
because I knew they couldn't prove it. So with any case, with any criminal case, in particular, because they've got such a high burden of proof, they've got to be able to prove those essential elements. And that law is so new that when the police charge it, they don't really understand how detailed that law is going to require their evidence to be, because they don't, the police don't necessarily need to look at the evidence. They just need to look at whether they can file a ticket and potentially get probable cause on the ticket itself. So they're not worried about proving it. To prove it, though, especially on the mag ban, how do you prove when you bought the mag, right?
Correct.
And it's not your job to prove when you bought it. It's their job to prove when you bought it.
Correct.
And so their problem is they don't have access to any of that.
Yeah.
They don't have any idea. They can look at the mag because they'll seize it and it'll be in evidence. But what does that tell them? Nothing, usually.
Correct.
Not enough to prove a case. And so
what about the idea that, because we all do it here in the state of Colorado, allegedly, the parts, buying parts and then assembling your own magazine. I don't know. I don't want to put you on the spot because, yeah.
So the whole buying of parts, the serial stamping of parts now, the requirement that you can no longer print parts. I mean, those prohibitions have been circling around that entire area for a long time. So there's a bunch of stuff around that. What specifically is your question? Because I've got ideas about how to deal with that, but I have I represent firearms dealers. I have not had to deal with ATF showing up at the door, knocking on your door, asking about your your filter.
In fact, one of us, we share a mutual friend. One of your clients is a friend of ours, Skyline Firearms.
Yep.
If we were to say, I bought a parts kit at Skyline Firearms, I'm not saying he does that because he's a home-based FFL. He doesn't sell magazines, so don't go to him for magazines. This is just an example.
Right.
For everybody listening, I'd don't go to him and bombard him with, I want magazines, because that's just an example.
Yep.
So if I were to buy parts from him, like what's the law say, or how do we navigate that, right? Because I don't think it really specifically says anything about parts and buying parts and assembling them, and it really doesn't.
So point me out to which.
Yeah, it's 1812, part 3. If you want me to pull it up, I can. But really, what we should be looking at is the technical guidance, right? Because there's a technical guidance for this, so it kind of makes the law itself kind of a moot point, if I'm not mistaken. And I think that's the problem, is that a lot of people don't read the technical guidance when it comes to the mag ban.
So while you're bringing that up, or while you're pulling that up, what is the weight of the technical guidance in a case? Like, what weight does the court give that, or in instructing a jury or something like that?
So usually what happens is, if there is technical guidance that provides descriptions and a definition, like what you have in exactly that page that you pulled up there, that ends up in a jury instruction. The jury instruction is read to the jury, and then we end up arguing to the jury off of that instruction. So when you tell them what the law is, these help flesh out what the law is. And so I've argued for crafted instructions at times. I have argued that these definitions add to the existing definitions, and you can tailor your instructions to your case. Any of the language in any of these regulations can be used to flesh out what the jury is going to get as a definition of a particular crime, or a definition of an element in a crime. So that's how this stuff works. When you're talking about large cap magazines, I think the jury instructions straightforward, and it allows me to defeat a lot of those cases just from the get-go. ATF has got tons of publications that they send out on things like, here's a good example: machine guns. Remember the definition of machine guns that they expanded to include bump stocks? Supreme Court knocked it down, and it wasn't on anything profoundly constitutional. They looked at the definition. They said it is, the definition of a bump stock does not match the definition of a machine gun in any of the statutes or regulations, and the ATF exceeded its authority by delving into an area they didn't belong in, right? They were there to regulate machine guns under the authorizing statute, and they expanded it to include something that is like a machine gun, but is not consistent with one, right? One pull of the trigger does not automatically make that firearm fire repeatedly. So Supreme Court just struck that down, and probably rightly so, because without really, and you've heard me talk about this before, without really clear language in the law about what is prohibited, how do you know your conduct has gone beyond the scope of what's permitted? And you will not know, because the definition is not clear enough.
Yeah.
So with the ATF's redefining of a machine gun be somewhat equivalent to the Attorney General writing their own technical guidance for a new law?
Yeah, so we deal with stuff like that all the time. We deal with Public Utilities Commission on, towing companies. We have stuff like this all the time. And so what happens is, you have an authorizing statute that gives an agency some power to regulate a particular scope of commerce, whether it be, magazines, firearms, bump stocks, towing regulations, anything. Well, the authorizing statute always says that the agency is authorized to publish regulations on scope of X, whatever whatever their concern is. And then the regulations can easily exceed the authority given to them by the legislature when they just start writing up rules that keep expanding their power to go beyond what was described by the legislature. And that's when you run into that problem of going beyond the scope of the authorizing statute. Run into an ultra vires problem, is what it's called. And this has come up repeatedly, but more importantly, it's come up with the Supreme Court now, both bump stocks, and then there are some other areas they're delving into where they're reining in agency power, and voiding or mooting some of their authority to go after sort of the expansive reading that they take of their authority.
So I would say, like for the magazine ban, the argument from the citizen side or the offender side would be that the spirit of the law was not to prevent me from enjoying or even servicing my own property, but only to prevent me from buying new magazines. So if I did buy parts to assemble a magazine, I have a perfectly reasonable explanation for doing that. That's within the spirit of the law. But the law is actually not clear on this particular topic.
Right.
Yeah.
And so can you still get charged? Sure you can.
Sure.
You
Yeah,
can get
sure,
charged
you can get
because they'll still
charged.
have a problem with it. Can you be convicted? That's a different question. Again, it comes
Mhm.
back to can a district attorney try to prove beyond a reasonable doubt that you knew that when assembling that particular magazine, you were violating not the spirit of the law, but the letter of
Mhm.
exactly how that law was written originally, and not
Right.
whether it violates, additional guidance or regulations even, um, but whether it violates the actual content in the law. We end up arguing stuff like that all the time because the exact phrases that are used by the legislature are always important,
Correct.
including getting at times, if you've read Court of Appeals cases, it gets right down to whether they used and or conjunctive or disjunctive. It gets right down to specific phrases in those laws, and the legislature has really the ultimate say on what they're prohibiting.
Yeah.
And some of the things if you've seen um, some of the firearms regulations that have been passed recently, some of those things are not carefully written, probably by people who don't understand how the industry actually works.
Correct.
Or the items themselves,
Right.
how they work.
Yeah.
Yeah,
This
exactly.
is always very interesting, right? Because and this is where I think a lot of people get it confused. It's just like the law can say all kinds of things. A cop can still charge
So
you
gotcha.
for it.
Oh yeah.
Yeah, you
Oh
can still
yeah.
be charged for it. Like let's not get confused about what it means to be charged and what it means to be proven correct or incorrect once you're in trial. And by the way, in trial and then appellate court, if you decide to appeal it and go even further, and I think that's where a lot of people get confused. I'm currently fighting a traffic ticket based off of jurisdiction. Everything around me said Broomfield, and all of a sudden a Westminster PD officer stopped me. Like, well, this doesn't seem like an okay thing. And I think the judge erred in a few things, so I'm appealing it to the district court. And for me, it's important, right? For me, it's like this: we need to have a decision off of this, and maybe I lose, but at least now I know that they can stop me in West UPD can stop me in Broomfield, and vice versa, even though that's not what the statute says in any way,
It's not
shape,
what
or
the
form.
law says. Yeah,
It's
that's
not
right.
what the law says.
Particularly in the case of the magazine law, the legislature has decided this go around to try to attack the source of the magazines by making the state patrol or the state police charging them with the task of enforcing gun laws and doing gun investigations, and also licensing FFLs through the state. So now they have a mechanism to investigate and to prosecute, and a mechanism to restrict business. So magazine sellers that I know who didn't care at all what the law said and openly put magazines on the shelf, when that law goes into effect, those magazines are coming down. Uh, they've put the risk now on the business itself, and you know I don't agree with the law in any way, but it makes perfect sense to me why they would go after it in that way. It's an expeditious way to achieve their goal, which is to restrict or diminish the number of magazines in the state. So yeah. So anything else on that, Edgar?
No.
Okay.
I think that's all the time it deserves.
Yeah. So kind of in the same vein as getting arrested and charged with something when you might not actually get prosecuted, or you very well may win your case, I wanted to talk a little bit about what happens from the moment you call 911 to the moment that you may or may not be informed that you're being charged with a crime. Like, you've had a lot of clients, 20, how many years? 27 years now?
It is, I have to think about this for a second. 97.
That's how long.
It is
That's how long.
27. It's 27 years as of October 21st.
Okay. So nearly 27 years as a criminal defense attorney. I'm sure you've done a variety and a depth of self-defense cases. I know I'm familiar with a couple of them. I'm sure you've had plenty of clients end up in that position where they've defended themselves and they or someone else called 911. And I just wanted to talk about your experience and then your recommendations for dealing with that interval time between the 911 call and maybe talking to a detective. Because everybody knows, hey, you should get an attorney before you talk to a detective. But a lot of people don't really know what it looks like between the moment you stop defending to the moment that you're sitting down with a detective.
So let me ask specifically, Isaac, do you mean from the time an incident occurs until the detective sits you down in a room somewhere?
Yeah. So, I was in my front, this hypothetical, I was in my front yard, some tweaker, pulled a knife. I pulled a firearm. I didn't shoot, let's put it in that more likely scenario. I have pulled my firearm. The tweaker ran. The neighbor called the cops saying, hey, my neighbor's pointing a gun at somebody. Maybe I called 911 too and said, hey, somebody attacked me and, come to my address. What does that typically look like when the cops show up? From your experience dealing with clients, what does that process kind of look like?
So if this is specific to a show of deadly force, even if it's just menacing of some kind,
Yeah,
even
we'll
if it
put it up at that
involves
felony
something,
level.
yeah, if it's felony level and it involves menacing, it can be anything, even a pretend weapon. You've heard me talk about this before. So a felony menacing, and there's a reason why I'm starting with sort of that description. So a felony menacing can be pretending to have a weapon. You can have a finger gun inside of your sweatshirt. It doesn't matter if it
Simulated is what the law
acts,
says, right?
yeah, if it acts or looks or is portrayed to be, just even if you pretend that you are armed, threaten that you are armed, it's all menacing, right? And if you do that under the right circumstances, it's definitely a felony. As soon as you do that, sorry, screen just changed. As soon as you do that, the circumstances for you are going to change pretty quickly, because police run, don't walk to a call like that. You may have seen recently, Denver Police Department said they were no longer going to be conducting low sort of impact service calls. So that means not a lot of traffic calls, not a lot of registration or expired tags. They're going to stop going to calls about probably motor vehicle theft. If you've ever tried to report your stolen trailer or jet ski, it's usually a written report that you end up submitting online, because they honestly can't be bothered part of the time. So auto theft, all of that stuff, they don't even respond. But if it involves a firearm, and if it involves the discharge of a firearm or display of an actual firearm, if they get any kind of report about a firearm at all, it's everyone comes running. And so you've got to think, first of all, about your own safety, and you've got to think about the one thing I tell everyone over and over again, although I swear half the time people don't listen. But when I say don't fucking talk to the cops, I mean don't fucking talk to the cops. It is not in your interest to call 911. Even if the neighbor calls 911, great. But 911 is a recorded call, and that evidence is produced in every single case, right? Every single 911 call they get, I got access to. So if you call and you're under a lot of stress, you're emotionally distraught, something has gone on, potentially you've fired your weapon, if you get on there and start talking, there's no telling what you're going to say. And so I try to tell people over and over again, just don't.
Can you think of any examples off the top of your head that you've seen where somebody did something that seemed not that big of a deal to them on that 911 call, but turned out to complicate their case?
Oh yeah, all the time. And so I'll give you the most mundane example. And this is how people get arrested for stuff they didn't even do a lot of the time. The detective, when they call you up, usually, and so this is after the fact. So after the stress and whatever happens at the actual scene of an incident happens, the detective calls you up and just talks to you and wants to know a little bit more and what's your side of the story, and maybe I can help you out, and can you just explain some more. That's all recorded, and people start talking not about what they did, but they place themselves at the scene. They may or may not admit to having a firearm. They may or may not admit that they had some kind of motive. So they were angry. They say they were emotionally, upset at someone. They say they were reacting to something. They start explaining, and they're not necessarily talking to you to get you to confess. What they want is time, place, and circumstance and motive. Because if they can establish any of those things from you talking on the phone, they've got one more piece of the puzzle that they need to file their case. And so the phone conversation always seems so innocuous. And I literally, I think I just did this last week. I said, don't respond, because they're going to call you and try and get you to talk on the phone. And the next call I got was, well, I talked to the guy for a little bit. I'm like, what did I just say? And of course, what he did was he gave him just a couple little pieces. But look, they don't have those pieces until you open your Yap. And you're not supposed to be there to provide them with those pieces. They're supposed to get out and go find them. That's the way criminal investigation is supposed to work. You are supposed to have the right to remain silent. If you don't exercise it, that right's gone. So let me go. So in terms of what I've seen I've seen people admit to doing something wrong that they weren't even being investigated for and get in trouble for that instead. I've seen people put themselves, the most common one, not the most common, but the one that infuriates me is road rage incidents where they think there's something in the guy's hand. The guy says it's a cell phone, but the other party says, no, it looked like some kind of firearm or weapon. And the guy gets arrested for menacing. And how's he going to prove what he had in his hand now? You got two people in the other car saying this guy was acting crazy, screaming at us, yelling he's going to do something to us. And he waves something in the air, and they can't immediately tell what that is in the middle of a heated incident. And so Joe, normal guy, says, yeah, I was there. Yeah, I yelled at him. Well, now there's time and place. And you had something in your hand. Yeah, I had my cell phone. Okay, so you had something in your hand. And you don't own any firearms. Well, in fact, I do own a firearm. I've got a black Glock at home. Really? Would you mind bringing that in so we can take a look at that? When was the last time you handled it? When did you shoot it last? Blah, blah, blah. You're just giving them pieces that if you were quiet and remained silent, they wouldn't have. But you're helping them out because you think you're either going to talk your way out of it or they're going to be sympathetic to you, neither of which are ever going to happen. Not once. They are not there to be sympathetic, and they're not there to help you out. They can tell you they are, but they're not. So back to the sort of menacing, sort of basic menacing sort of case.
Mm-hmm.
I've had cases where menacings occurred, especially in traffic, and someone actually calls a firearm because people are, racing along, cutting each other off, brake checking each other in traffic. I've had cases where people were shot in traffic before. And I will tell you a hypothetical, and this one sort of drives me nuts, but hypothetically, you could get in a road rage incident and be brake checking each other in traffic, and the other guy can shoot you, and they will not charge him. Now, I'm not saying do this, but they will not charge him because your vehicle is being used as a deadly weapon at the time. You don't think about it that way, but think about sort of high speed, brake checking each other, trying to run each other off the road or into traffic, the danger and risk that poses, and then someone pulls out a firearm. The police can just as easily say it's your fault for starting the road rage incident and arrest you for the road rage incident as it is to arrest them for shooting you.
Right. So your aggressive driving is being
Yeah.
interpreted as the initial act of aggression.
And
Yeah.
you initiate it, right? You
Mhm.
initiate it, and it's aggressive enough, and you're using what could be considered a deadly weapon, and so they don't have to charge the guy that shot you. Now they
Mhm.
should, because they should, right? Because it's a self-defense situation where, depending on the circumstances at the time, if you're stopped in traffic and arguing back and forth, and he, shoots you,
Mhm.
did you pose enough of a threat if you're out of your car or in your car, if you're already stopped, if you guys have crashed and your radiators are smoking and you can't move anymore? Like, what's the circumstance right then? But I'm saying there are circumstances there where the cops can decide they're not going to bother. They're not going to
Right. And
bother
the cops
charging him.
cops don't have to prove that you had intent.
Right.
They just need reasonable suspicion
They need
that
enough
you
information. Yeah,
Mhm.
enough information that they can corroborate what they think your intent was.
Right. So if you said something like, "Well, I brake checked him and then he shot at me,"
Yeah.
then there you go. You've got your act,
Yep.
your reasonable suspicion
He was
for
he was,
arresting
he
you.
was making me angry. He wouldn't stop. He wouldn't leave me alone. I was driving behind him and he wouldn't get out of my way. I did have a bad day at work. I was kind of angry at the time,
Mhm.
et cetera, et cetera. If you got anything like that, you're building a case for him. So um so let's just go back to your original question. The original question was sort of, what's that interval like between when something happens and when the detective sits you down in an interview room? And so here's the series of events. How it usually goes is, um, incident is over and you hear the sirens, and you put the firearm down in a safe condition away from you, and you back away from it and you get on your knees with your hands up, because they're going to come running in hot and they're going to have guns out, and you can't be the one guy on the other end of that still holding his firearm. You got to be either on the ground or ready to go to the ground, because that's the next thing they're going to tell you to do. They're going to cuff you up. They're not even going to bother talking to you. They're going to put you in the back of a car, and you're going downtown at that point. There's probably no way out of it. So put that out of your mind. You're not getting back out of that car until you're downtown at holding. So once you're in the car, you got to take a bunch of deep breaths. Remember, you can still get bond. Remember, you can get an attorney. Remember, you've got family behind you. Remember, you probably didn't do anything wrong or not enough to be convicted, and you just got to breathe for a little bit. And remember that number one rule: don't open your yap. They'll take you downtown. They'll want to book you. They'll take your photograph. They'll stick you in a holding cell. You'll be in there with junkies and drunks and the rest of it. You just got to put up with it. At least, back in the day, that's what Denver was like. You'll sit there. What they used to do was, they didn't even interview you on the scene. If they did, it was by a patrol cop that just wanted to see if he could get your story out of you. And if you told him, "I'm not talking to you," he would just take you downtown, put you in the holding cell. The detectives used to come down to the holding cell first thing in the morning at roughly 6 o'clock, 7 o'clock. And what they would do is pull guys out one at a time and take them to interview rooms down the hall in Denver, and they'd interview them down there. When they just got you up, it's your first night in jail. You haven't had a phone call or anything else. You barely eaten, because they used to just feed you those, apples and cheese sandwiches that they had back then, or bologna sandwiches that they had back then. So you didn't have much to eat, and you're in shock. So they'd take you out, bring you back to the interview room, be nice to you for a little bit, and try and get you to talk. And it worked really good. That's how I got arrested, by the way. Because as a public defender intern, I would go down there, and I started going down there early because I realized what they were doing. I go down there early and I get all the guys together and I'd say, "Look, detectives are going to come down here and talk to you. They're going to want to take you out one at a time and get you to talk. If you talk, you're going to be in worse trouble than if you shut up. So my advice to all of you is shut up." And they started refusing to go down the hall with these detectives. Detectives didn't like it. And when they caught me doing it, they said, "You stay here. We're going to go get a warrant." And so I had to wait upstairs in the jail while they went and tried to get a warrant to arrest me. And I asked the sheriffs, like, "Can I go downstairs and finish my job? I'm supposed to be doing bond arguments in court." And they said, "No, you got to wait here." The detective said, "You have to stay." I'm like, "All right, I'll wait." So I sat my ass down, and eventually the judge sent someone up and said, are you coming down? Like, what are you doing? I said, no, I'm under arrest. I got to wait here until the detective gets back. Judge said, what? And had me come down, had a detective come in. And the detective, who I later got along with, and we became okay friends, but detective came in and said, my other detectives said he's interviewing, obstructing, obstructing police operations or obstructing justice. I said, I'm not obstructing justice. I'm actually here to help administer it because I'm here to advise everybody on bond, their right to remain silent, and their other rights that apply to a trial and a case. And I said, my advice to them, honestly, is that they don't talk to you or any of your other detectives. And the judge said, that's right. That's entirely what he gets to do. And there's another statute that says you cannot prevent an attorney from having access to a client, which is what they had been doing. And the judge said, Denver could be violating that particular statute by preventing Mr. DeBauche from doing his job. And so they had to let me go, and I got, kept doing the same thing the next couple of days, and they eventually decided they'd just come in after I was done with all the bond arguments and all the advisements. They started coming at 10 in the morning instead of 6. But that's
so
how I
that's a kind of a typical thing to kind of expect and anticipate. There's always this debate, right? And a lot of it is between the attorney side and the instructor side of, I've seen, me personally, we've had 20 students who've had to use their gun in self-defense. Some of them have talked, some of them have not talked to the cops when the cops show up. And it's always a fear or a concern that they don't say anything and the cops have nothing to go off of other than there's a dead guy and the guy with the gun. And they say more once they're in that jail cell and the survival kicks in, and they start yapping more, versus some of our students who, and again, every circumstance is going to be different. You're speaking for what is common and what is typical. Some students have been in a position where they do say, hey, that person, the affirmative defense, right? That person did the thing and they did the defender thing, and everything else I'm gonna shut the fuck up about. Where is the line of say absolutely nothing and say stuff to not go to jail, or is it always just safer to shut the fuck up, but don't be shy or don't be afraid when you are in jail and your fucking brain tells you find a way out? Don't look for a way out, just get comfy.
Yeah. People have got to learn to shut the fuck up, because what happens is, as I said, they're looking for a couple of puzzle pieces that don't have yet. Yeah. By the time the detective gets to you, he's got all the other reports from all the other witnesses, and they get to you last. And so the reason they do that is because they want all the other information to filter down. And then they're going to tell you, well, I've got all these other witnesses that identify you as doing this and being this kind of aggressor and, attacking the other party. And to be honest, they can make it up. There've been cases for 40 years that have said that the cops can make stuff up in order to get someone to talk. So are you helping yourself out? Is there a likelihood that you're going to help yourself out of a bad situation by talking to the police right then? And let's assume it's the scenario I talked about. So you get arrested, you go to booking, you wake up the next morning, they knock on your door. Hey, we want you to come down and talk to us. The answer is no. I will not talk to you without my attorney. So number one, you want the protection of an attorney before you make any statement. Number two, you want to screen your story through an attorney so you know what parts of your statement are going to make zero sense, or what parts of your statement you should never bring up voluntarily, or what parts of your statement you should stress. Number three, you don't even know if you're charged yet. You don't know what you're charged with. You don't know what you're explaining. You don't know what they're investigating you for. And I've had it where they've arrested someone on what they thought was some crime they committed, but investigated them and interviewed them on something completely different, took them completely by surprise. But at the time they realized it was too late, because they've been yapping on about details they thought were innocuous. Turns out they're not. So always wait until an attorney has been appointed or assigned, especially if it's any kind of first degree murder. Public defender is immediately assigned to you and sees you the next day. And it's important to wait until they get there, because you don't want to be the guy who goes into the public defender's interview room and says, well, I talked to the detective for an hour this morning already, and I filled out a whole statement and signed it with my name, and I put my thumbprint on it, and I confirmed it on camera for them. That you don't want to be that guy, no matter what. And let's assume you think you're going home if you just explain your side of the story. Even if your side of the story is makes you out to be golden boy of the year, if they've got 1 or 2 or 5 or 6 other witnesses that all identify you as doing something wrong, you are still not going anywhere, no matter how credible you look, right? You can have a priest collar on, and it ain't gonna matter, right? Because they've got enough behind them already that they're not necessarily going to tell you about, but it's enough to already arrest you. Yeah. I've had them. I just had this happen where detective waited until the end of the investigation to call the client. I call him up and say, client's not coming in, not volunteering for anything. I'm not going to allow him to be interviewed. That's it. And they get mad. Well, then I'm going to issue an arrest warrant. I said, if you're going to issue an arrest warrant now, you were going to do it before I told you that.
Correct.
You were already writing it. So that does impress me, right? Because I've seen that over and over again. Most of them who've been around for a while, like, yeah, okay. We'll let you know when you can turn your guy in. I'm like, okay, just give me a call. And that's the end of it, right?
Yeah.
Because they understand sort of how this stuff works. So back to the example you talked about. So you're arrested, you go to booking, you see a judge for bond the next day. They advise you of the charges you're being investigated for, and you bond out and you're out. If you're not bondable for some reason, if there's, if they're holding you because they suspect it's actual, that's an actual murder, an actual first degree murder, if they try and hold you without bond or hold you with an incredible bond like $500,000 cash, then you've got to just wait and sit tight and find an attorney and hire an attorney and get an investigator and start doing the work that it's going to take to fight the case. But you can never assume that you're going to talk your way out of a situation with a decent detective.
Yeah.
It's really, really unlikely.
Once you're in booking, once you're in the interrogation room, it's a different story, right? Yeah.
Yeah, exactly.
For sure.
Exactly.
So in that let's go back to like you're on the curb, mm-hmm. right? And you committed a violent act that would normally be a felony. Mm-hmm. And the tweaker who threatened you or a family member with a knife, took off running before the cops showed up. Is there any value in telling the police, yeah, some guy attacked me. He was wearing a white t-shirt and no pants, and he ran east on, Oak Street about 2 minutes ago?
Okay. So that's a good question. So let's look at the different ways that scenario is going to play out. You tell him it's a tweaker in a t-shirt and pants, and he ran that way, and they go and find him. What's he going to say? He's not going to say, I waved a knife at this guy and tried to, get him for his wallet so I could, go buy more crack. He's going to say, the guy came out screaming and threatening me and I ran. If the tweaker's actually going to stand there with the cop and admit that he was one waving the knife around to begin with, then yeah, you're right. You win the lottery at that point. But my best bet is Mr. Tweaker is not going to admit to that. He's not going to say that. He's going to say exactly the opposite because he wants to keep going. He wants to keep running. So when they stop him, assuming he doesn't go to jail on a possession charge right then and there, they are probably going to talk to him, and he's probably going to try and inculpate you, right? He's going to identify you. So no, it doesn't help to tell him, Tweaker ran that way. He looks like this. Leave that for the other witnesses. Leave that for someone else to describe, because your best result in that situation is they never find him. And if they don't have a victim, they don't have a named victim at all. And that's one of the elements usually in those assault charges is you assaulted a person specifically, tweaker X, right? If they can't find him and can't identify him and can't get him to corroborate anything, case is over, usually.
So would there, I guess there would probably be some argument to saying that if you knew that there was some continuing imminent threat to somebody, like, he was waving a gun around and he ran into Starbucks.
Mm-hmm.
And the reason you're doing that is more of a, hey, like people are in danger right now, not go get the guy who assaulted me.
Right.
So
because that's not even an assault at that point. It's just a danger to well, it's not an attack on you that's you're worried about. You're just he's a continued threat to society.
Right. And you're not doing that to help your case. You're just purely doing that to assist in public safety.
Right. Yeah.
Knowing though that, anything you say is still potentially
Correct.
bad if you did something, right? If you did pull out your gun and wave it around.
Right.
We talk in our classes, especially from a self-defense point of view, like we don't deal in absolutes. So we would not say you would absolutely never point out the attacker to the police. The reason to do it would be because there is an imminent threat to somebody that there is an imminent threat. Not like a tweaker running around Colorado Springs with a knife.
Right.
Like that's always true.
Friday night. Yeah.
Yeah.
Yeah. I usually, like in classes, I usually don't tell people to describe. I used to, and I stopped just off of recommendations from having conversations with cops. Is if you are one of the people who calls the cops and you give descriptions of yourselves or other people, like cops are just looking for people. And if you give them the description, like the chance of them fucking finding you because you were part of the description is like, well, I heard the thing and you were the described and now, so like even doing the description stuff is kind of one of these weird situations where like cops at the end of the day, we can argue how well or how untrained they are. I think most would argue they're not very well trained. They're still human, right? They're still processing information the same way everybody else processes information. They're not unique. They're not superhuman. So if a dispatcher is giving them information, chances are they're just receiving it as mumbled as anybody else would be receiving information. Now all of a sudden the guy in the white shirt and the jeans looks like the guy holding the gun, defending themselves. So like the description has always been for me, well, at first it was like, yeah, describe yourself. Now it's just like, don't even fucking bother describing anybody really to a certain degree, because the cops are receiving that information. If you describe who you are and what you look like, they're trained to be looking for bad guys, not good people, and the information gets crossed.
Yeah.
So what about the idea of just stating, as the cops show up and they put you in the back of the car and you say, hey, I am going to cooperate, but I'm going to do it through an attorney. I just want you to know that this is you've clearly invoked your right to an attorney. However you make that clear, you've done that, and then you say, this was self-defense. Is there any benefit to doing that? So it would be a spontaneous utterance, right? You've already shut down the avenue of questioning, but you have volunteered just the single argument that this is a self-defense case. Is there any benefit to that with the cop at the scene?
No. So self-defense there was just a Supreme Court argument here in the state about self-defense. And that's actually a little twist on the law that we should talk about at some point. But if what you're doing is telling them I was defending myself, then you're admitting that you used a degree of force to defend yourself. You definitely place yourself on scene with this other individual, and you're trying to make them out to be, the initial aggressor. Some of which they may know, some of which they may not know. But when you file self-defense as a defense in a case, it means you're admitting to the use of force. You follow me? And you may not want to do that. There are a lot of reasons why you may not want to do that, but there was a recent Supreme Court case called Martinez, and before that there was another case called Pinnell in 2011. And what it says is the clearest case for self-defense is usually, some kind of intruder or attacker in your home when you've got, the Defense Against Intruders Act to take advantage of. The next step down from that is you are using a level of deadly force to respond to a level of deadly force, right? And you've got, an attacker, and you're defending yourself against an attacker outside your house, in your detached garage, out in public somewhere. You're in King Soopers during a mass shooting, stuff like that, right? You're still clearly defending yourself. And self-defense operates as an affirmative defense in those circumstances. That's the clearest example is equal but opposing levels of force are used by two parties, and one of them has a self-defense argument. The other one has to be the initial aggressor and can argue self-defense. That's just the way the law sort of works out. What this recent case was arguing about was...
Is it the Martinez case?
Yeah, it's the Martinez case that they just argued literally this week.
Yeah, out of Adams County?
Yeah, and so what happened in that case was... I was going to call it, sort of night of drinking and fighting. So guys are out drinking and fighting, and the two, Martinez and his friend Huerta, come back to his house, and they're fighting over whether or not they're going to keep drinking. And Huerta begins to punch Martinez, hits him, and Martinez grabs a shotgun and fires it at the floor, and it somehow kills Martinez. The other friend that was present said it was the craziest accident he'd ever seen, but he believed it was unintentional. And the guy went to trial and tried to argue self-defense. And he was acquitted of the higher charges, but they convicted him on reckless manslaughter because it was a reckless act that resulted in the death of another human being. And it was only reckless because he didn't point it at him, but he discharged a deadly weapon in a manner that could be considered to disregard a substantial risk that you're going to hurt or kill someone. And so they convicted him on reckless, and he said, I should have had the advantage of an affirmative defense of self-defense in that case. And the Supreme Court's been pretty consistent saying no since 2011. What they said was, you can argue it's self-defense, but it's not an affirmative defense. And that makes it harder for a defendant. It makes it harder because you no longer can argue that the DA has to disprove your affirmative defense, because it's not affirmative. Now it's just a defense to being reckless. So what it says is, in circumstances where I'm defending myself, if I am reckless, you, the jury, can find it me not guilty because I was not reckless in that situation. I was acting in response to a threat. That's sort of what that says. Now here's the way the sausage is made. They don't have a great jury instruction on that. They don't have a great jury instruction on it, and it has been tossed around in the law enough that everyone agrees we have a hard time sort of understanding at the trial level what imperfect self-defense really means. And that's sort of what I'm describing here is you think you're defending yourself, and you are, but you don't have the advantage of forcing the DA to prove that your self-defense argument is wrong. And so, there goes additional elements they'd have to prove to find you guilty beyond a reasonable doubt. Suddenly you lose those self-defense elements. And so when you see people convicted of reckless type crimes like reckless manslaughter, that's how that happens.
Yeah.
So you're saying essentially in that initial investigation, which is on the curb, we're trying to not give them anything at all in hopes that the investigation will just fall apart before we even maybe get to a formal charge. Mm-hmm. If we do get to a formal charge, a formal arraignment, then we're going to make the self-defense argument. We're going to provide the statement, the witness and the statement, or the evidence and the statements to support that argument, which is typically an affirmative defense. Mm-hmm. And we're going to we're going to make a case that's so hard on the investigation and the prosecution that hopefully we'll get these charges dismissed based on the self-defense argument.
And that does happen. So that
Okay.
can happen. You saw it happen on the Dolph case. If you remember that riot case with the one guy with the tear gas and the other guy was a security guard.
Yeah, downtown Denver.
That was dismissed just a few weeks before the trial itself.
Right.
And I was surprised, but I get it. I get the result. So it's, two guys having this argument, and one of them pulls out a can of bear mace and starts spraying it, and the other guy could potentially be incapacitated by the bear mace and just be vulnerable to whatever the other guy wants to do to him at that point, right? Could seriously hurt or injure him. And it wasn't a small can of mace either. I mean, he was blasting him. And he shoots him. I thought it looked like a degree of force that would be difficult to argue is reasonable, but the DA didn't feel they had enough. And usually what happens, so you understand, is I bet you that trial took at least a little over a year to set up. You went through preliminary hearing, you went through motions, you had your investigators running around digging up the information that you knew about because you hadn't talked to the police in advance. You were able to dig up enough stuff on the other guy probably to show he had either violent tendencies or, had prior crimes in his past. You dug all that stuff up and you looked at your guy who had training, was a security, was, I think, a security guard in another jurisdiction, not Denver, was at least somewhat responsible with his weapon, had taken the appropriate classes, and had a CCW permit, had done all of those things. And you took that to the DA and said, I don't think you're going to convict my guy, and I don't think it's worth our time to try and convict him because he's got a fairly flawless background, and your guy has got, some marks on him, and you're going to have a difficult time proving your case. And they look at whether or not they want to spend, 2 weeks in a trial on that case as opposed to a dozen other cases they've got on their desk with maybe higher priority and fewer warts on it, and they decide they're going to get rid of yours. I mean, that's honestly how some of this stuff goes. You work on the case long enough and hard enough, and you have enough good information on your end that you decide you're going to share it and which pieces you're going to share. And it's at that point it's chess not checkers, and you're trying to give them a picture of what this trial is going to be like and letting them know, I think that this case is not worth pursuing. Take it to your supervisors and see if they agree. And sometimes they do, honestly. Sometimes that's the kind of assessment you get out of a DA's office when they've had enough time to toss it around, look at it, and sort of match it up against what they expect the rest of their year to be like if they spend 2 weeks on this trial and not some other trial.
So yeah, with the Doloff case, I was not surprised by the outcome, but I wouldn't have been surprised if it went the other way. I wouldn't have been surprised if it went to trial and if he was convicted or if he was acquitted. I mean, it was such a gray, I don't want to say gray area. It was so open to interpretation by 12 or 14 potential, jurors that it was kind of a toss-up, and I could see the city of Denver deciding that they've got more important things to do than to pursue a second-degree murder charge where they really don't know what a jury's going to say about that. Yeah. So I think everybody was acting stupid in that moment, and I know that was a setup, but that it's not really important. There's somebody dead, and it's like and that's another thing about what people tend to ask in classes is like, what if this happens? What if this happens? What is this? If this happens, what is going to be the legal outcome? And we try to stress to people, like, there is no way to predict the legal outcome of a self-defense case. And we don't teach to the law. We teach to defending yourself and understanding the legal risk in the aftermath. So
let me talk about Martinez real quick so you sort of understand. So let's assume you make the tactical choice to share Doloff's information with the DA ahead of time, hoping that they'll dismiss it a couple of weeks before trial. What if they just decide to proceed to trial on a reckless manslaughter charge? For exactly the reasons we just talked about.
Yeah.
Because their burden of proof is lower because they don't have to disprove an entire defense now. It's your job to prove it, and you are stuck putting on witnesses to support that defense. They don't have to disprove it anymore. And so you have given up an advantage. They have time to follow up on your information. They have time to adjust the charge down to what they think will survive, right? A motion for acquittal at halftime and then the rest of the trial. And they can try and convict your guy of something less. What if they do that, right? And so as an attorney, you're always sort of, you get to that point where you think you might be able to convince them of something. You got to decide what you keep in your pocket and what you actually tell them, because that can be the reaction. I've had DAs do something just like that, where you tell them, hey, you have this problem with your case. It looks to be, a fatal flaw, and suddenly it gets fixed. I've seen it go so far as to have an officer take the stand and testify differently than what his report said, right? Change the facts around. Oh, I was wrong about that. I wrote that down wrong. It's actually this, and fix the problem, right? Right at emotions here, right in the middle. So I've had that happen. You cannot, exactly what you said. You can't predict the outcome of any individual really criminal case without knowing the background, the circumstances, the criminal histories on each side, the particular personalities on each side, doing the legwork, getting an investigator out to look at stuff. It takes quite a bit, especially on the more important cases, to flesh them out and get them ready, even for discussions with the DA about what a potential plea looks like. It is it becomes more of an art at that point, right?
Mm-hmm.
So the law looks like it's a dry and straightforward sort of practice, but the DAs do the same thing. They look at the practicalities by the time they've got the potential for sitting there 2 weeks with jurors and witnesses and support staff and a judge tapping his foot waiting to get to his next case, and a lot of that stuff comes along and goes into those sorts of decisions. The understaffing at the jails comes into it. You can only put so many second and third DUI offenders into a jail that is bursting at the seams, and so people start getting better and better sentences as the jails pack full, especially in the middle of summer.
I try to make the point to students that despite what people think, the criminal justice system is actually fairly efficient at the task that it has. And part of that efficiency is decisions to dismiss charges, to not charge in the first place, in the spirit of let's focus on most important things and let's process all this other stuff. So a trial is like the least efficient part of the criminal justice system, and it's the least predictable part of a criminal justice system.
After spending time in jail, I would disagree that it's efficient.
Well, so you'd have to ask the question: what problem are they trying to solve?
They solve not a fucking thing.
Yeah.
Me in jail.
And I mean, if you're the one sitting there waiting for your phone call, if you're the one waiting for all that stuff, it sucks. But if you look at the monumental task that the system is being given to do, human beings tend to look for efficiencies, and a DA, a detective, a judge, the goal is to process cases. And from the state side, the goal is to get convictions. Mm-hmm. And so a plea deal to a minor felony or a couple of misdemeanors is a conviction. Mm-hmm. And let's get that paperwork signed and let's move it along. Or, you know what? Like this defense attorney is being a royal pain in the ass. We really don't have the witness statements we need. Let's move on. Dismiss case. It's not always as clean as that. I get the impression that generally speaking, given the job that this system has to do, it does it fairly efficiently. It doesn't feel like that when you're in it at all. But when I've talked to people who've gone through their cases for whatever, all different kinds of stuff, it seems like the goal is always to get to a resolution as quickly as possible. The state wants a conviction, but when the state realizes they're not going to get one, they want that case off the docket. They want to move on and get rid of you. If the jail is too full, let's get rid of you. Let's move on. That's right. I'm not defending the court. I'm not saying that I'm okay with it. I'm not rooting for it. I'm just saying generally people's impression of this is that it's some behemoth that just decides with no morals or anything, just like, well, we're going to take a giant shit on you because you're the citizen and watch what we can do to you. And like, they don't have the resources to do that for no good reason. And most of the people working in this system are just doing a job. They're just signing papers and moving stacks and, so I don't remember where my point was with all that, but the idea of getting
You're trying to
charged.
status now,
Yeah.
and that you love the government.
The idea of a charge. And so, because I've been telling people for a while, making the like working with the police at the scene by expressing that you will cooperate, but that you are not going to answer any questions without an attorney is initially setting up, hey, I'm not a bad guy. I mean, I know you think I did something wrong, or everybody else says I did something wrong, but I'm not going to fight with you. I'm not going to argue with you. I will cooperate with you, but I'm going to do it with an attorney. And then the next thing, I tell them, like, it's not a bad idea to set up the self-defense argument, but you're laying out, why give them even that? Why even go down that path? Because now with the self-defense argument, you're essentially saying, yes, I did do that. And you might not even have to do that to get the case dropped. Yeah. You might not even have to tell them what happened to get the case dropped.
That's right.
So with that, this kind of question that was posed earlier kind of comes into play, right? This opinions on filming stuff. It kind of seems like now you would almost say, don't fucking record shit, because now you've got.
No, you know my line on that, I think. So if you remember my talk, I've got specific circumstances under which we record and preserve evidence. The ACLU has got an application, and let me give you the exact name of it so I don't screw it up. I think it's called. I'm not going to have it.
I'll bring it up while you.
The ACLU has an application for recording. It's a golden tool. I do recommend filming every situation on a phone, whether it's your phone or not. Is a different
just mobile
story.
justice, ACLU mobile
That's
justice.
It. Mobile justice. Okay, so mobile justice is an application designed specifically to keep evidence in your own hands, and what it does is it activates a web camera that records to a cloud storage device and preserves whatever is recorded separately from your phone. So if your phone gets seized as evidence, crushed under a car tire, you lose access to it somehow, anyhow, right? You don't lose access to that because they will still have a copy of the entire video. It's not kept locally. It's, stored remotely.
It looks like they haven't updated the app, so if you've got a newer phone, you can't download it.
Okay, so the other way you could do it is, depending on your phone. The thing about phones is the law has taken a while because they sometimes turning them is like turning a glacier, but they've come to recognize that phones are vitally important, including all the way up to the Supreme Court. Even those guys have recognized how vital and important phones are. And where in the old days I went to court carrying a briefcase with 20 pounds of junk in it, and pads of paper and pens, all I carry is my phone, right? Because I've got more power on that phone than I ever had in that briefcase. And so I tell people, if you're going to record, exactly what Max just said, you can record to a cloud drive, but you have to have security on the phone, something other than just your fingerprint usually, but you got to have security on your phone so people can't just access it, because if you're running around with an open phone, the police are free to go through it.
I'm surprised how many bad guys do not have any password on their phone. Because
why? Yeah.
I watch one of my favorite shows is First 48, because I think it gives one of the least filtered perspectives on investigations. Mm-hmm. And it's incredible how many of these people just have their phones with no lock on it at all.
And so sometimes they're carrying burner phones that they don't think they're going to use for longer than a week. But to be honest, why would you not have some security on that thing?
Yeah.
And the courts have been clear. If you don't have a password or something on it, You don't have to surrender the password, but if you don't even have the password, they can go through it and sweep it.
That's like having
Um,
an unlocked safe in your house, right?
yeah, it's like handing them a book and saying, I really don't want you to read this, but here it is. Yeah,
Hmm.
like that. That's not going to stop them.
Yeah.
So you have to have security on it. You got to be able to hit that record button at a moment's notice, and they can't stop you from recording. You always see law enforcement officers asking you, what's with the video? Why are you recording this? What's the problem here? And trying to make an issue out of it because they don't want you recording them. But obviously, right in the middle of their chest is the body worn camera, which they're supposed to be using, according to most departments' policies. They're supposed to be using it during citizen encounters. But I can tell you, a lot of the times what they're doing is that you might see the light on and it might be recording the video, but they turn the audio off. And they do that because they're going to talk to their buddy, or they're going to, call up someone else about the case, or they're going to make some statement about, what a jackass you are, or how they just want to, stick you in the back of the car, teach you a lesson, like stuff like that, doesn't make it on the audio. Sometimes, to be honest, it does, and they don't realize they left the audio running. So those body worn cameras, you do have that to sort of lean on, but you can't assume that the audio is being picked up, and you can't even be sure that it's aimed the right direction to pick up, the appropriate footage on video.
Yeah.
So it's up to you to record some portion of it if that's what you want to do, but you got to have it behind some kind of
Hide it.
firewall. You
Hide it.
got to have a
Yeah.
wall around it.
So I kind of want to backtrack a little bit
Mhm.
for the Martinez case, and then I really want you to talk about the stuff that you said we need to go back to. I think something about the self-defense things. I forget which issue it was.
Mhm.
But one of the interesting things that I was reading in the Martinez thing is that it was his friend, and it was at his home,
Mhm.
and he got quote unquote make my day,
Mhm.
which then suggests that even if it is family or friends or somebody whom you know, you're still covered under the make my day law.
So, I think you and I have talked about that before. So, um, the burglary statute's a pretty good example of sort of the distinction between an intruder, which we all think of when we talk about a burglar, and then just someone who is no longer authorized to be there,
No
which can
longer
also,
invited.
no longer has permission to remain inside the dwelling. So you kick someone out, which I'm guessing is what happened here with Martinez's friend Huerta. I think what he said was, "I'm done for the night. You got to get out of here. You can't stay here." So he's trying to kick him out, and he doesn't want to drink anymore. And Huerta's like, "No,
We're
I'm
gonna drink.
yeah, I'm gonna whoop your ass, and then we're gonna drink." And so he grabs a shotgun, and crazy things happen when you unload a shotgun inside of a house, and somehow a pellet got him, and Huerta dies. The it 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 To be honest, what they're struggling with in that case is, shouldn't the make my day law apply in a blanket way to any use of force, even deadly force, and why would it change to accommodate a reckless crime? And it runs up against that old Pinnell case from 2011. That Pinnell case just seems like it creates a class of almost accidental crimes, like you recklessly discharge a firearm, you recklessly run into somebody, you recklessly, seriously injure someone, and then suddenly you can't argue it's self-defense anymore in the same way. And so I think they're struggling with what is, and we can't call it the make my day law. They said we're not
Yeah.
supposed to call it
Yeah.
that anymore. So
Correct.
Defense Against Intruders Act, Huerta qualified apparently as an intruder. Huerta qualified obviously as an attacker, and he's using force against Martinez, and Martinez grabs the shotgun. Now I've told you in the past, don't bring a gun to a fist fight, because that is automatically setting you up for an argument that your response was unreasonable. But he wasn't trying to shoot Huerta. He was trying to warn him off or just get him out. And unfortunately for him, when the gun goes off, it doesn't just hit the floor. So I think that this case could be hugely important. This case could have a ripple effect up and down the system. So I'm wondering on what they're going to do to rule on it, because you can see them struggling with their prior cases. You can see them struggling with the legislature's clear instructions in the Defense Against Intruders Act.
Yeah, if you go read if you read all the citations under the Defense Against Intruder Act, there's a lot of case law in there.
Wow.
And I think that speaks to how complicated home defense really can be from the legal point of view. And a lot of people assume that home defense is the simplest self-defense argument. And as you've said it before, it's your strongest argument, but that doesn't mean
narrow.
it's simple.
Yeah.
And there are a lot of ways that your case could be compromised in ways that you couldn't have foreseen.
Right.
And that can also work in your favor when the prosecution gets a hold of your case and says, well, we have no idea. It's not worth our time. I recalling that case in Denver where that guy who was visiting his cousin, asleep on the couch, had only been there for that night, and an intruder came in and he stabbed him. He stabbed the intruder to death. And the Denver DA comes out within a week, I believe, if memory serves, and says, yeah, we're going to go ahead and basically call this guy a lawful occupant because we don't see any reason why we're going to pursue this case, and knowing that all of that case law about what an occupant or not just an occupant, but who actually constitutes an intruder and who had a reasonable belief that they were allowed to be there, and all kinds of things can go into that. So on the note of recording, if you had a dash camera that has onboard storage, you're kind of shit out of luck if they spot the camera.
Yeah.
Right.
That's right. That's exactly right.
But if you had a dash camera that did not record locally, but instead recorded via cloud, you have some barriers between you and the police getting that footage.
Right.
But not great barriers. Maybe they can subpoena it.
Right. They can subpoena it. They can issue a warrant for it. They can seize it with a warrant. They can try and crack it open later. I mean, other than iPhone security, there aren't a lot of things keeping them out of most devices. And even with iPhone security, they've been able to get past that. So, encryption is the only thing that really defeats, some of their forensic tools, and their tools are getting better all the time. So you never know what they're going to have access to.
Yeah.
So in general, would you say that the defendant's recordings and videos have historically been helpful or unhelpful to their case?
Almost always helpful.
Okay.
Almost always helpful because they almost always capture everything from beginning to end. It's usually someone's recorder running in their pocket or a phone that's on record, running on a dashboard somewhere. And so, if
I would imagine that if it was incriminating, you wouldn't present it as evidence.
That's exactly right. That's exactly right. It can stay wherever it is because I'm not going to use it. But if it's not incriminating, and I've got the story about the deputy sheriff out in Park County that was nailing that guy's wife, and then showed up to a supposed domestic violence call and tackles the guy and arrests him for assaulting him. The recording made it clear, but we didn't disclose that until we were halfway through the preliminary hearing, and that got the case dumped. That got the case dismissed because the cop clearly perjured himself on the stand, lost his job and became a security guard somewhere. But stuff like that is saved by something as simple as a little, $20 recorder in your pocket. Phones are ultimately, far more powerful, and people have used them to great effect. Even just, for traffic stops to sort of, record exactly what goes on in any particular interaction with police. And, sometimes, little phrases become really important, especially when it comes to motions hearings, when you're trying to suppress a statement or convince a judge that your guy was, was under duress when he gave any statement. I mean, the only way we know what happened usually is if one of our clients had made the decision to record a lot of what went on at the roadside.
So I have another question about that kind of intervening time. So let's just say defended myself, committed something that's normally a felony to do that. I have time to make another phone call before the sirens. I call an attorney. I call my attorney and say, hey, I just defended myself. Gun is secure. Cops are on their way. Is that phone call a good idea if it can be made safely?
Oh yes.
In that intervening time.
Oh yeah, I've gotten those calls. I've gotten those calls at all hours of the day. So you get those calls, and it's always the sort of the same discussion. Like, don't talk to them. When they take you in, I'll be down there. Do you have somebody that can bond you out, and who should I call? And just don't say anything, right? Don't say anything. If you need to, take your ID and leave everything else in the house or in the glove box of the car, and give your keys to your friend and just wait, because you're gonna get, if you committed a felony or are involved in any kind of menacing a firearm incident, you're probably going to the holding cell. You're probably going to sit there overnight. You probably just need to be prepared for it. That's just part of the potential risk of using, displaying, or even pretending to display a firearm. That's just part of it. So you're going in. Don't pretend you're going to talk your way out of it. Just prepare for it.
So the value of that conversation is really to kind of reinforce the instructions you would give anyway.
Yep.
And also, get you started, make sure you have a full tank of gas and you're on your way down to the jail.
That's basically it. Yeah.
So.
Yeah. I've had them hand the phone to the cop. I mean, or the cop, they'll get the number for the cop standing there while they're, sitting around. And before the cuffs go on, and I'll get the phone number, and I'll just give the cop a call and say, what are you doing? Where is he going? How long is he going to be there? Please don't talk to him. I'm telling you, he's got a lawyer. I'll be there if he's going to give an interview. Don't talk to him. And they'll usually have to honor that, right? When it comes to invoking your right to an attorney, you've got to be crystal clear about it, and you've got to insist on it. You can't waffle, and you can't change your mind later, and you can't try and talk to the cop about anything else, because the conversation is going to sashay back to topics that I've told you not to talk about. So you've got to be super, super clear. There's case law that says, just talking to the cop about, asking them questions about whether I should have a lawyer, or maybe I should stop talking to you guys. Maybe I should get my lawyer in here. That's not clear enough to actually invoke your right to an attorney and stop the questioning. You've got to tell him, I have an attorney. I want him present for any questioning. I can't talk to you. He's told me not to.
So typically, would you say that the clients that you've had, self-defense or otherwise, who have been disciplined about that, have had much better outcomes?
Oh yeah.
Oh,
absolutely. Yeah.
Okay.
Yeah. So, if they don't have the information and you don't give it to them, then it's in your pocket to use later, or in your pocket not to use later. You're still in control of it. Once you give it up, you've lost control over it, and you lose control over that part of the case, so that piece. And it may become really important later on. You don't know if you're, sitting on the curb. You don't know how this is going to go, what's going to become more important, what they're going to be really, really looking for. You don't know what they're looking for when the detective talks to you, and you're definitely not going to know what they're going to be looking for a year from now when they prep for trial. So, you can be cooperative, you can be polite. If they tell you to go here, you go here. If they tell you to sit there, you sit there. But when it comes to talking to them, they can have attitudes about it all they want, but it's your right to stay silent.
And sometimes I get resistance on that from people who, their idea is like, well, if you're not guilty, you don't have anything to hide. I mean, we're all familiar with that. And the point I try to make to people when they say that is, these rights that were enshrined in the Constitution, these rights that were specifically called out, are to protect you, the citizen, from the state. And you are now entering an adversarial relationship with the state. And you have these rights because a tyrannical state is one that controls all of these things. You are when you give up your control to the state, you are voluntarily giving up your equality of I don't even want to use the word equality. You're giving up your sovereignty as a human being.
That's right. Exactly. And
So
so let me talk about the exactly that topic, but I want to go back to the Dobbs case. So you remember the anti-abortion case. I don't care about most of that language in there until we get to Justice Thomas, who said something about the rights not being described in the Constitution clearly enough just do not inure to the benefit of its citizens. And that's the opposite of the way we should read that, right? The way we should read that Constitution is those rights that aren't alienated to the state remain those of the citizenry. So exactly what you're saying, and the reason I disagreed with the language in that opinion is you should have all of the rights that existed before the Constitution was written, right? Life, liberty, happiness, and the rest of it. You should have the right to go down the street, to carry a firearm, to hunt, to hunt fish, all of that. You didn't give those up when they formed this country. You didn't give those up except for real limited rights that they said would become something that the state could regulate. And so when they look at that document, they shouldn't be reading it as if it's a list. They should be reading it as if it's a list of exclusions. These are the only things we can do to you. That's what it should say, right?
mhm,
That's what way it should be read. These are the only things we can come after you for.
mhm.
And the rest of it, right, should still be yours.
Yeah, and I remember there was plenty of argument before the Bill of Rights was added to the Constitution. If we put all this in a list, aren't people going to read into it that if it's not in the list, it doesn't exist?
That's it. And
Yeah,
that's the
and
exact opposite way to read it.
right, and eventually the argument came out like, well, we got to be crystal clear that the citizens have rights, and we're going to write these down. But exactly what the founders' fear was has come to pass.
Yeah.
And so, and when I put it in that context, usually I get some connections in people's brains. They're like, oh yeah, I get it, and then they go talk to a cop and they're like, oh, and this is what I did. What is going on with people where they understand the concept but they are unable to apply it in that moment when they need to? Like, if
Mhm.
you've got face-to-face experience with more people than you could count who've been
Mhm.
through this, is there anything that kind of clues you into why it's so common for people to not protect themselves in these conversations?
Um, so there's the obvious things, and then there's the not so obvious things. So when it comes to talking to police, there is sort of the way we act on an everyday basis. There is the obvious, survival instinct to try and talk your way out of a problem. There is that same thing you just talked about. If you're innocent, what do you have to hide? And that's exactly the wrong way to look at it, as you know. But that's the way people think. And there is just the absolute terror of I don't want to go to jail. I don't want to go to jail. I don't want to go to jail. It's going to be shameful, and I'm going to be embarrassed. And I'm going to sit there, and I can't get out. And what's going to happen to me, and what's going to happen to my kids and my job, and the rest of it. So there's fear. So that's all the common stuff. But then there's the not so common stuff that you don't think about. So um, police have had training classes for decades now, where they study and work with uh, body language and statements and demeanor and what they can and can't say in interview rooms, and they've studied it and they made a science out of it, and there's classes on it, whole courses, whole books.
Incorrect, by the way. Incorrect
Right.
training.
Yeah.
Because it's been
Yeah.
disproven time and time again
Uh-huh.
that this training is absolute bullshit.
Yep. But they
But
use it. They
yeah,
can use. They People don't understand that they can use deception. People don't understand they can misrepresent the evidence. I've had police tell people we've got DNA evidence linking you to the crime when they could not possibly have conducted DNA testing in the time period they're talking about. So over and over again, right? They've got advantages on their end that people don't understand, and what it comes down to is most people aren't trained on even sort of basic. I mean, basic constitutional law, interactions with police, the rights of the state versus the rights of the individual. Most people don't have any clue because you never really get it, right? You might have a government class in high school. It might spend a little bit of time on it, but they're not going to talk about what do you do when a cop comes knocking. They talk about this is what the Constitution says, but that doesn't tell you what it does, right? It doesn't tell you what you can do with it.
Yeah.
So we're not educated to use
Yeah.
it.
I think also too for the lawful self-defender, the prudent person who has decided to, get a concealed carry permit and follow the law as well as they understand and all that stuff. These are typically people who have not had a lot of conversations with police, especially investigative, their interactions with cops probably for the most part has been, getting pulled over, which is a pretty, generally speaking, what's the word, like routine type of stop.
Yeah.
You obviously were speeding, or you made an unsafe lane change. You're right. I'm sorry. Here's your ticket. Here's your court date. Move on.
Right.
Being part of an investigation is a whole. I mean, I know a traffic stop is an investigation, but being part of a real criminal investigation is a whole nother animal. Edgar's had his own experiences. I've had my own experiences. It is uniquely terrifying to some degree.
Yep.
The first time it happens, and it's very disorienting.
Mm-hmm. Yeah, and so it puts people on their back foot, and it puts you in a vulnerable situation, and it puts you in a situation you're just not prepared for, and you're neither trained nor educated on how that that encounter is going to go and what's going to happen to you next. And so it throws you in the grease.
Yeah, I almost tell students, even low level shit, you're better off not knowing anything and just assume you don't know shit and just let the fucking attorney deal with this stuff. Because if you're gonna even pretend to know a little bit, the Dunning-Kruger kicks in, and then now you believe you know more than what the fuck you do.
Yeah.
Or you have to actually dive balls deep into knowing the stuff to the point where you have to be fucking flawless on knowing this stuff. So for the average human being, for the average student, it is almost better to not know a fucking thing about the law and just let your attorney deal with everything that has to do with the law, even if it seems insignificant, right?
Yeah.
Because it gets you into a lot of holes that you don't want to be in, even if it is just a standard. I went into Walmart and they're trespassing me, because it's like you say, now you think you know the fucking law and you start citing shit that's not fucking true, and you turn a simple trespass into, all of a sudden it turns into a criminal felony menacing because you're yelling at people and they know you have a gun. But you're yelling belligerent about how the Second Amendment and your rights, and all this shit. So like it's that fine line of like, I get it, you want to know the laws, but what the fuck are you gonna do with that law, with that knowledge?
I try to use that as a jumping off point with people to just tell them, like, this is why this stuff is so incredibly complex. You don't believe me? Well, here's some information to help support why I'm telling you why we don't teach to this stuff and why you shouldn't plan to do this on your own.
Right.
And it's funny because in the classes when I start talking about this, I will very, very clearly state that if you ask me if something is legal or not, I'm going to tell you I don't know. And they continue to ask the same questions, and I continue to give them the same answer. And it's like, it just doesn't click.
Yeah.
So
the answer is always, it depends.
It depends.
Yeah.
It depends. It's mind-boggling how people just don't understand it. It depends. It depends. I do a little exercise when we watch a video, and I pretend I'm the prosecution team asking your general, like, the guy's running away. Why are you shooting him? People are like, well, it's because I don't know what he's going to do. And then I just let them fucking dig themselves their own hole. Like, you could say all that what if and future stuff, and because it's not imminent danger, or you could shut the fuck up and just let your attorney deal with the trial shit, and you shut the fuck up, because it's very easy for anyone to try and justify that they were correct. Like, but I want to tell you how correct I am and how right I am.
Yeah, especially if they feel like they righteously acted, right? Like
Yeah.
I was watching a video. It's kind of come back around. This video is actually a few years old now, but the guy's case I think just got adjudicated, and he killed his neighbor who was speeding on his street, and it was all on camera. You know, they got in an argument, and then he
Yeah.
shot him and killed him. He shot him in the back, and he's sitting there telling the cops like he knows everything. I know.
Oh
You know,
no.
I know your chief. Like he's telling the cop all kinds of
He's got
stuff, you
some
know.
special, yeah,
Right. And you
special
can just
knowledge.
tell that
Okay.
this guy just believes that everything he does is right. You know, and so he's taking that into his statements to the police, and he keeps telling the cops what they can and cannot do. You know, you got to give me my phone back, and you got to cuff me up front, and like all this stuff. And it's just wild the way people will get into that idea of like, well, I know better than you, so here's all the reasons why you're wrong, and you're just digging yourself this huge hole that you may never be able to get out of.
That is nightmarish. Yeah, yeah. Occasionally we'll get clients like that who try and, you know, sort of tell us this is what the law is, and this is how this is going to go, and this is how a jury trial works. And
You should tell
I'm
him, you know,
like,
you can
man,
save yourself a lot of money and just
let me,
let me off this case.
yeah, yeah. Let me tell you, like, I can try to predict how stuff is going to turn out, but you're talking about, you know, in county court for misdemeanors, it's 6 people in a box, and a felony, it's at least 12.
Mm-hmm.
You're lucky you can predict what flavor of pizza they're going to order, much less what they're going to do with a complicated case that they spend, you know, 3-4 days hearing. Like,
Mm-hmm.
you can't predict that stuff. It's basically a crapshoot.
Yeah.
So I mean,
So
yeah,
to anybody who's like at that level, I always say get a traffic ticket and fight it on your own. Like actually go through the trial
yeah,
and actually present evidence
Yep.
and go through discovery
Mhm.
and go. It's fucking batshit crazy. Like it is overwhelming. The you have to file if you're going to file motions, they have to be done on certain time frames
Mhm.
depending on the crime. I mean, I know I'm speaking to the fucking choir here, but like it is not just say I'm innocent and show up to a court day, say I'm innocent some more, and then all of a sudden it fucking goes away. Like this is, and it go through a traffic trial all by yourself, represent yourself, and then afterwards be like, I still know fucking everything, and I like you don't like it just it's incredibly complex.
Mhm.
It's fun. It's a lot.
And traffic trials, to be honest, are they're like, you know, criminal law light, because you don't necessarily have rules of evidence. You've got you know, not real strict rules about exhibits. You've basically got a trial to a judge if it's not, you know,
Yeah.
a major ticket like a reckless driving ticket or something. But it's a great introduction to the back and forth inside the courtroom, the procedure between, you know, the officer testifying and you presenting evidence. It exposes you to cross-examination, so you
Yeah.
can see, not only do you get to do it, but you get to see it. Um, and it you know, takes all those crime shows that you've seen on TV and sort of distills them down to, you know, maybe 5% of what they put on TV is roughly accurate. You get through an actual court case like that, you'll think very differently about the stuff you've seen on TV or anywhere else. It's nowhere close. And then you know, a step up from that would be like a, you know, a county court civil case, like a collections case for something under $25,000 would be a really good example, because then you do have rules of evidence and rules about when exhibits are due and rules about when witnesses are endorsed and how to endorse them all, and you know, how to make copies of everything and provide them in advance, and how to present them and actually admit them. I mean, a lot of those rules and things are, you know, sometimes pretty complicated, and you know, that there's limits on what a judge or jury will even hear. If your evidence gets, you know, barred because you didn't follow a particular rule, you've hurt your own case, and it's your own fault for it. And so, yeah, the 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 law takes a lifetime. It really does.
Yeah. So
You
next
know,
time people are like, "Why is an attorney $60,000, $70,000, $80,000?" It's like because it's a lot of fucking work. It's a lot of
yeah.
tedious, mind-numbing, hour after hour. And by the way, because I'm giving you proper representation, I don't have 300 clients like a public defender does, and stuff like that. So it's kind of important to know that just let your attorney do the job, right? Like it's
Yeah.
You had a point earlier that you said we should come back to, and maybe we're all going to forget what that was.
It was the imperfect self-defense
Oh.
sort of angle, and I wanted to sort of cover that so people understand why reckless manslaughter seems so common. When you see serious cases, you all of a sudden see people convicted of reckless manslaughter, and they get 10 years. So you think it sounds like a good self-defense case, and then they get something like that, and so I wanted to sort of point out there's a whole sort of subtopic under self-defense that is imperfect self-defense, which is sort of what we were talking about earlier with the Martinez case, and why can't you get an affirmative defense in a reckless manslaughter type situation? Why doesn't it apply universally to any use of force? Why is it limited in some ways? And they've those rules, you're not going to find them in Title 18 because they're not. They did. I mean, the legislature did amend the statute somewhat to accommodate some of what was going on in the case law, but most of it's in cases that you have to be aware of before you put your hand on the door of the courtroom.
Yeah.
And if you don't have an attorney that can sort of do that kind of stuff, doesn't have that experience, and doesn't know to do those things, you probably need to find a different attorney. It's almost 27 years, and before that I was working in a criminal defense law firm as a clerk, and before that I worked in 2 different public defenders offices. So I spent 30 years doing criminal defense at this point, and I've done all kinds of stuff. I've done investigations, I've done filing, I've done plenty of drafting, and I've done lots and lots of trial work. And it after almost over 2 decades and heading on 3, I appreciate now that the depth and the breadth of what it is you have to know on any particular case. I mean, I've done jury trial after jury trial. I've done civil and criminal. I've done stuff in every court system in Colorado, and then in the administrative courts. And they're in the law. There are certain things that sort of run through it that are at least somewhat consistent. That there are rules about how evidence is admitted in every court. There are good practices and bad practices. There's always the need for background investigation and someone to do your footwork. You always have to know when your deadlines are. I mean, there's common themes in every single court, things you can never ever miss. And so experience counts. Experience counts.
Yeah,
for sure.
Yeah, absolutely.
So there was a case out of Texas, and maybe we can kind of wind down with this just as an example, a kind of an extreme example of the immediate aftermath. The guy in the taqueria who shot the armed robber in the on camera. I don't know if you're familiar with this. It happened, I think, in January of 2022, and or 2023. Armed robber comes in, starts stealing everybody's money, pointing a gun at everybody. Our defender,
I do remember this.
Yeah, our defender waits until his back is turned and draws and fires and shoots him. At which point, our attacker starts to fall, and the defender continues to fire, and then gets up and walks towards him and continues to fire, and then puts one more round, kind of to make sure he never gets up again. This guy left. He didn't call the cops. He didn't, stick around. He left, and the Houston Police Department put out an APD because they had a pretty good picture of his truck, which was an older model pickup truck, and he turned himself in, I think, 4 or 5 days after the incident, but with an attorney. He had a year-long grand jury investigation, and he was ultimately no billed for murder by the grand jury. Kind of a wild case because he he didn't do the whole like, oh, stick around, call 911, put his hands on his head. He just dipped. And that appears to have not hurt his case, because the grand jury didn't say, oh, well, he left, he must have been a murderer. Like, what is your impression, not to say advice, but what is your impression of that kind of response to that, and then the outcome?
So I was just reading through some of the notes on this, and I think I get what happened. So when he shoots him, the guy is literally 2 feet away from him, facing away, still holding a gun and robbing people, and he gets him, right from the side, so almost point blank, and he got him apparently enough times that he was down right away. Do you stop shooting at that point? There's nothing really saying you got to stop shooting, right? If you're using deadly force, it's to potentially make someone pretty dead. And so does he have to stop? I mean, not if the guy's still got the gun, not if the guy's still moving, not if the guy still seems like he could be a threat. You don't have to back up, run away, stop shooting, or be nice to him. You don't have to seek medical attention or anything else. So I don't. So the grand jury, when they saw that case, the one thing that hurts him is the flight. Because flight can be used as evidence of guilt. I mean, that's a standard doctrine in criminal law. Flight can be used as evidence of guilt. So if you flee, they can use it in front of the jury with a special instruction. If I remember the instruction right, it says they can actually use it as evidence of your guilt. So do you leave? I mean, I might leave the immediate area because this guy is still there. I would probably get to safety, but I wouldn't split. And I wouldn't, split for 5 days. I would probably wait. And the reason is exactly because of that instruction. So I'm not surprised by the result. It looks like there were people calling for him to be charged as some kind of vigilante, but you're always going to have that kind of, minority voice in the community, because most of the community is going to say, look, you're in the middle of an armed robbery. And if you shot the guy, you shot the guy.
Yeah.
And it doesn't sound like a crime.
The grand jury is going to see that third person point of view video.
Yeah.
The defense to that will be, well, like, you weren't on the ground, you weren't seeing what I was seeing, and the bad guy was still moving. But from what I understand, for grand jury, the defense doesn't get to make the argument. It's only the prosecution gets to make the argument. So because of that, I was a little surprised that that they didn't come back with a charging decision, except maybe to say that maybe the Houston Police Department, or not Police Department, but DA's office just didn't put a lot of effort into it.
Put the thumb on the scale a little bit. Yeah, they could have. They could have just soft pedaled it to him and shrugged it off.
Yeah.
Because I mean, to be honest, I mean, a trial like that, the murder of an armed robber. I mean, you're in Texas, right? So how many jurors are really going to be part of that minority voice saying,
especially robbing like the most popular taco stand in the neighborhood?
Exactly.
Yeah.
So fleeing and not calling law enforcement can be used as evidence of guilt.
You don't have to call law enforcement, because probably when shots are fired, they're going to get called anyway. You don't have to be the one on the phone. If you are the one on the phone, you don't have to say much. In fact, very little. And yeah, honestly, in his situation, I don't think I'd bother at all. I think what I would do is, like I said, gun in a safe position, outside on the ground, wait for the cops to show up, because the sirens are going to be rolling as soon as the shots are fired, and someone else can take care of the calling the cops. What you can't do is leave. So don't volunteer information to 911, but also don't flee the scene, because that just invites, number one, a chase, and number two, sort of a more forceful apprehension later, which you can avoid just by staying put. It's gonna suck for the 24 hours or so that you're not bondable, but that's part of the suck you're gonna have to embrace.
Yeah, it was an interesting case for sure. It definitely made the rounds in the gun world for what appeared to be an anchor shot on camera. a lot of people being like, well, that's what you got to do to make sure they're stopped. And a lot of people saying, well, you're going to go to jail for that, which turned out to not be true. And so, and the fact that the guy left, and the fact that, it's Texas and there's a grand jury requirement for the homicide. So all just kinds of crazy stuff with that story.
Yeah, definitely.
All right.
Awesome.
Edgar, you got anything else?
A ton of shit. I mean, there's always a lot more, but I'm looking at the time, and Brian does not charge us for this.
I don't.
So we're on he's on his own time, volunteering this information for humans to be better prepared afterwards. So although I do have a bunch of other questions and a lot of topics, I think in the interest of time, we can end it.
Okay.
I appreciate your time. Very valuable information as always, and I'm always happy to hear. And I don't know how it happened. I don't know if it's because of us. I'd like to believe that it's because of us, but I'm always happy to hear students and shop owners say, "Oh, I use that lawyer that you have and that you talk about," because then I know they're properly represented. I mean it genuinely when I say that I've talked to a lot of attorneys, and you really are one of the ones that is very knowledgeable in all of this stuff. Not just experience, right? Because you could be experienced and still be a dipshit.
Experienced dipshit.
Like you could go to trial all day long and still not learn from all of this stuff. And that's just not the thing with Brian. So if you guys are looking for an attorney, we talk about this in our classes, is like, look for the attorney now. Like, don't wait till you're in jail. Don't wait until you're cuffed, because at that point you're just gonna choose the first fucker who answers the phone. Like, you're doing the phone calls, the first one who answers. Do it now. Obviously we have a bias with Brian, but if you don't have an attorney, it's worth calling his office and having a conversation with him. I don't know if you're looking for new clients or not. I'll let the office kind of decide that. But it's worth a call to Brian and start just planning right now, right? Like, you hope and never need Brian, but like let's start planning that stuff right now. Just
and you're probably never going to kill somebody in self-defense, but you probably will find yourself in a circumstance where you have to make some critical decisions that are high stakes, and that very easily can result in a bad day, a bad week, or a bad year, legally and financially speaking. So.
It's the argument. I forget who said this, is not us, but it's really good. Like, the argument isn't about how likely it is that you'll be in the circumstance. It's what's at stake, right? Like, that's the argument. What's at stake is your freedom. So it's nice to have a conversation with Brian, and get an attorney. That's, at the end of the day, just get an attorney. But why not Brian? So I appreciate your time. I appreciate your knowledge. I appreciate the information. I appreciate those of you that stuck around and came out. Share it. Tell other people about it. Tell other people about Brian.